Good afternoon. My name is David Gallo from the AIFC Academy of Law. I'm the director. Welcome to all of our participants joining us from across the world, the UK, Europe, Middle East, and of course, the Central Asian states. Welcome to everyone. We appreciate your attendance in today's event. This is part 3 of a webinar series that we started a few weeks ago called The Room Where It Happened, virtual classroom with AIFC advisory experts on the development and application of the AIFC regime. And as many of you may well know who have participated in some of our earlier events, the AIFC Academy of Law is focused on preparing lawyers for international commercial law practice. We're operating in a global commercial environment here in Nur-Sultan, Kazakhstan at the AIFC. As most of you know, we are a common law English language jurisdiction that was formed with the intent of attracting foreign direct investment, with a particular focus on establishing a robust capital markets infrastructure, with the idea of creating investment opportunities that would drive the economic development vision of the Republic of Kazakhstan. The Academy looks to fill gaps in traditional legal education, if you will. We have a common law jurisdiction within the context of the broader civil law national Kazakhstan legal system, and the Central Asian states have similar legal infrastructures. And therefore, in order to maximize access by legal professionals into the AIFC ecosystem, we want to make sure that we are cross-training lawyers in different systems so that they are fully equipped and ready to transact business, and we hope have long and prosperous careers within the AIFC system. So we have a very special event here today. This Room Where It Happens series is near and dear to my own heart because we have the privilege and honor of welcoming members of our AIFC Legal Advisory Council. And I will formally introduce Mr. Simon Cox, who will be our keynote speaker kicking off the event today and who is a member of the council. Well, the council was there from the beginning. So when the legal system itself was being formulated and various options were being considered, well, this is the committee that was really looking at what are the global best practices that we can pick and choose from, and what system of laws and dispute resolution institutions will be most fit for purpose for the Kazakhstan and the broader Central Asian region. So we're very fortunate to have Simon here with us. And we have an extra bonus today. In addition to Simon, we have 5 other speakers who happen to be senior legal officers and senior business leaders from across the various AIFC bodies. So you can't get much more expertise than that in terms of people with know-how and experience, and who have, of course, a tremendous commitment to the success of the entire organization, and who are more than willing to share their knowledge and perspective with all of you, because we have a common goal, and that is to build a global commercial financial center that has international renown. So that's where we are. So with that, I'm going to go ahead and introduce all of the speakers in the beginning, and then we will turn it over to Simon. At the end of the last speaker's presentation, we'll then open it up for Q&A. And during the session, you can go ahead and, if you see your hand raising icon in the lower right of your screen, you can raise your hand, and when we get to Q&A, my colleague will call on each one of you. Or you can activate the chat function and you can write your question, in which case my colleague Almas will read that question at the end for whichever speaker it is intended to. If you could keep your microphones on mute, that will optimize our sound quality. And with that, let me first introduce Simon Cox. Simon's a member of the AIFC Legal Advisory Council. He has extensive experience of working on UK and international securities, including IPOs and other equity and debt security issues, mergers and acquisitions, and investment fund projects. He's a senior consultant at Norton Rose Fulbright, LLP in London, and much of Simon's work involves frontier markets and working on securities and M&A projects for natural resources projects. Nurkat Kushimov is the Registrar of Companies at the AFSA, which is the Financial Services Authority. Nurkat oversees actually the activities of two divisions. Not only is he the head of the Office of the Registrar of Companies, but also the head of the Legal Advisory Division. Mr. Kushimov has 13 years of legal work experience in government at different departments of the Ministry of Interior and the Ministry of Justice. Prior to joining the AFSA, Mr. Kushimov was the head of issuers regulation and head of the legal department of the AIX, which is the stock exchange. Mr. Kushimov is as I mentioned, the acting chief legal officer and is responsible for management reporting to the CEO, the AFSA executive body, the AFSA board of directors, and the AIFC governor in respective matters being handled by the legal advisory division. Nurkat Kushimov graduated from the Academy of the Ministry of Interior of the Republic of Kazakhstan Law Institute with an LLB in 2005, and he holds an LLM degree from the University of Cambridge, Faculty of Law. I have not met many people more impressive than Nurkat, so we look forward to his presentation today. His colleague, Razak Basari, head of Authorization Division of the AFSA, also will be speaking. Prior to joining the Astana Financial Services Authority, Raz was a deputy head, Insurance Supervision Division at the Cayman Islands Monetary Authority from 2015 to 2019. Raz is a seasoned regulator with over 20 years of financial services and regulatory experience. Before his time in the Cayman Islands, he worked for one of the leading banks in the UK, the Financial Services Authority UK, which is now called the Financial Conduct Authority, and the Qatar Financial Center Regulatory Authority. Raz holds various professional qualifications in financial planning, mortgage advice and practice, compliance, anti-money laundering, CFT, strategic management and leadership, and Islamic banking and insurance. He's also a certified anti-money laundering specialist and fellow of the Chartered Management Institute of the UK. Finally, Raz holds a Bachelor of Law degree, i.e. an LLB, and a Master of Business degree, an MBA from the UK. Next is Eugenia Bogdanova, Head of Regulation and Compliance at AIX, which is the stock exchange here, the AIFC. Eugenia has more than 20 years of experience working on international capital markets matters. Before joining the AIX, Eugenia had led legal, IB, and corporate governance teams at Renaissance Capital. Prior to that, she practiced law at White & Case in Moscow, advising in connection with cross-border and domestic equity and debt offerings, M&A transactions, corporate restructurings, information disclosure issues, listing requirements, and corporate governance. Eugenia graduated from the Russian Academic Law University and began her career at the Russian Federal Commission for the Securities Market, which has later merged into the Central Bank of Russia, where she was involved in legislative drafting activities relating to the Russian securities market, including regulatory reform allowing direct issuance of debt securities in Russia by foreign issuers. Our last speaker of the day will be Mr. Arman Tastambakov, Chief Legal Officer of AIX. I'm sorry, he's the second to last speaker. Mr. Tastambakov is a lawyer with extensive experience in capital markets, M&A, oil and gas, and mining industries. He has worked for over 17 years as an associate and partner with prominent international law firms and as country chief counsel for a FTSE 100 company. Arman holds an LLB with honors from Kazakh State Law University and an LLM from an American University, Washington College of Law in Washington, D.C. He's admitted to practice law in Kazakhstan and the state of New York, USA. Finally, Mr. Arman Batayev is a senior manager at the deal sourcing department at AIFC Business Connect, which is a phenomenally amazing business within the AIFC. And I'm certain you will look forward to hearing Arman Batayev's presentation. Arman has experience in audit at EY and KMG, finance, and structuring deals in AIFC. Today, Arman is with AIFC Business Connect Limited in frontline to source deals to the AIFC jurisdiction. And he also acts as a bridge between foreign investors, projects, and governmental agencies. With that, let me turn it over to our keynote speaker and member of the AIFC Legal Advisory Council, Mr. Simon Cox. Simon.
Ladies and gentlemen, good morning, good afternoon. After David's build-up, I feel completely inadequate, and I'm sure that the keynote speaker is entirely inappropriate given the company that I'm in. Could we go to the first slide, please? In previous sessions, we've dealt with a number of topics in the room series. Andrew gave a very eloquent presentation initially on the way in which the regime was evolved and the nature of the authorization process and the way in which it works. Last week, we looked at why the AFC legal and regulatory regime was based on common law and some consequences of that, and how the establishment, continued evolution of the regime provides opportunities for Kazakh international law firms and their clients, as well, of course, as a much wider spectrum of business interests. And the objective of today's session is to address, to myself and my fellow speakers, some of the ways in which the regime is actually being applied in practice. Can I have the next slide, please? A couple of the slides which I'm going to put up, I also put up last week, but I'm going to try and avoid any duplication of the ground that we covered. But underlying everything that we're all doing is this basic mission to which David has already referred, which is to contribute to the sustainable economic development of Kazakhstan and the region by fostering innovative financial products and services, by establishing an environment that delivers fair and transparent financial and capital markets, and in which individuals and institutions act with integrity. The next slide, please. So, what are the elements of the AIFC and the regime which are being applied to seek to achieve that mission? Now, we're obviously all operating in very unusual times. I'm not physically in my office at the moment. My understanding is that many of you in Kazakhstan are now back, albeit working differently. But over time, as we get back to normality and offices fill up again, there will clearly be a key element of the build-up of offices and ancillary service providers actually at the site. And I'll come on to a picture of the site for those of you who don't know it in a second. So that's the first thing, the physical infrastructure and getting people into the offices. The second is the regulatory concept of establishment, recognition, and operation of entities in the AIFC. I will come back to that briefly, but then subsequent speakers will be talking about that in greater detail. Likewise, the authorization and regulation by AFSA of certain activities which require such authorization by AIFC participants. Clearly, what needs to be authorized, the ongoing obligations, and what authorities that provides for activities outside the territory of the AIFC are clearly hugely important topics. AIX, and we'll come back to that, and David has referred to that, a new listing venue for fundraising and raising liquidity. I think this is one of the most exciting elements of the AIFC, and much of everything else is to some extent dependent on the build-up of activity at the AIX. the build-up of listings, liquidity will inevitably drive a build-up of the financial, legal, accounting, and other advisors servicing the companies who have a listing here. That doesn't mean, as I'll come on to in a second, of course, that the only clients for such businesses are AIX-listed companies or AIX or AIFC participants. But that will be, in time, a fundamental driving force for the development of the centre. Quite separately from all that is the AFC law, which we discussed at some length in the last two presentations. But their objective is to create, the objective there is to create a regime to govern domestic and international contracts in a way which delivers the requirements discussed last week for the businesses and other institutions who wish to use that regime to govern their arrangements. When things go wrong, dispute resolution mechanism in the court and the IAC, the International Arbitration Centre, again, are cutting edge systems for dispute resolution and part of the overall structure and offering of the AIFC. And then within that, there's the promotion and development of specific areas of activity. Have the next slide, please. For those of you who don't know it, many of you are probably in it at the moment, this is a picture of the AFC location. Amazing place with the highest grade technology, office space and facilities, and that is at the core of the physical location. And part of what all this is about is getting those superb offices filled with people carrying on the activities for which the centre has been designed. And I have the next slide, please. This is a slide I put up previously, kindly provided by the AFC team, and it shows the members of the bodies of the AFC and their roles. And a number of these are represented, but that is the overall structure within which everything is taking place. Can I have the next slide, please? So if we look at the elements in the build-up of putting the regime to work, we have those participants who are financial institutions, brokers, investment banks, and others. We have the non-financial participants, including lawyers, accountants, credit providers, and a whole range of other similar activities. We have the other service providers, such as hotels, restaurants, and all the backup of that. And in addition, of course, the AIFC bodies, which regulate, control, and promote the overall activities of the AIFC. And then underlying that are the businesses, the clients of the AIFC, if you like. Those companies which are using the AIFC to raise money or structure their organizations or to obtain advice on a whole range of activities, including areas such as Islamic finance and fintech, where the AFC is leading internationally with the development of financial technologies and mechanisms to service these growing areas of international business. And to some extent, this is circular. As the level of business picks up in the AFC, there will be a greater need for financial institutions, which will in turn draw in even more non-financial participants to advise them. And I'll come back to the way that may work in a minute. But also, there will be a build-up of momentum, and as the number of personnel, of course, increases, all the other service providers will benefit as well. If I could have the next slide, please. I'm not going to go in any detail on becoming a participant because it'll be covered later, but broadly, becoming a participant is available to entities which are incorporated in the AIFC, sorry, there's a C missing, or which are foreign companies or partnerships incorporated in any jurisdiction other than the AFC and become recognized companies through the recognition process. So both domestic and international business can become participants. Likewise, more complex regime perhaps, but the ability to re-domicile a legal entity incorporated in another jurisdiction if that jurisdiction provides for re-domiciliation as a technical possibility. Any organization which establishes itself as an AIFC participant but is carrying on regulated activity will also, as part of that process, need to seek authorization for those regulated activities which they intend to undertake in or from the AIFC. Could I have the next slide, please? As many of you will be aware, these are described as the main pillars of the AIFC, and they all have their own infrastructure, both technical and physical. Capital markets, obviously the AIX leading on that front, both debt and equity listings, asset management, and as part of that, the ability to create investment funds for accessing both domestic investments and also international investments. That is an area which I think has great potential as the SME market develops in Kazakhstan and in the region, establishing funds to enable people to get exposure to those companies, the growth companies of the future, has significant potential. Financial technologies, I've already touched briefly on that. Islamic finance likewise, and private banking, the whole structure of wealth management and other services to support the growing international structures and client base of the center. Could I have the next slide, please? I'm going to touch very briefly on some examples of practical implementation of the regime that we've been looking at in the last few presentations. And I'm going to touch on these only very briefly, but with the qualification that clearly there are taxation and other issues which are highly complicated, and they would need to be assessed in each case for the specific requirements and particular specific circumstances of each company seeking to do this. I'm going to talk very briefly about establishment of holding companies and finance companies, financial firms, law firms, primary and secondary listing will be dealt with in a later presentation this morning, and the choice of AFC law to govern contracts and choosing AFC court or IAC for dispute resolution. I'll touch on those very briefly in a moment. If I could have the next slide, please. One of the opportunities that we have identified, along of course with others, as part of the development of the regime is the potential to use the AFC as a basis for the creation of holding companies, both within for groups operating within Kazakhstan, mainland Kazakhstan, and elsewhere. The tax regime is a very specific tax regime, and I'm not going to go into the detail of that. And in summary, it is focused on financial institutions. So although by structuring the organization effectively, you may be able to achieve tax efficiencies, the AIFC tax regime is not available as such, for example, for a mining company or an oil and gas company. But the regime has provided opportunities for the creation of structures, companies, limited partnerships, limited liability partnerships with which international investors are familiar and which have been designed to provide for efficient and effective operations. So from that reason alone, it may well make sense to establish a holding company in the AIFC, which could then be marketed if the securities are listed internationally or attract international investors as an unlisted company, private company or public company will obviously have different rules for that purpose. It should be relatively straightforward, but this of course would depend upon the regimes in which the subsidiary companies operate to effectively put those companies underneath a new holding company on a share-for-share exchange structure, but that would need to be analyzed in the circumstances. So there'll be a holding company at the top holding shares, either majority shares, 100%, or indeed minority shares in the underlying structure. And it should then be possible to lend money down within the group, and this is, I think, going to be touched on in the AFSA presentation in a second, if those companies are authorized to provide credit to companies, particularly companies within their group. It may be possible for interest to be paid from the subsidiaries to the parent company without attracting withholding tax. And there may also be tax efficiencies for the company itself, depending upon how its revenues are structured in the AFC. I'd like to have the next slide, please. Another possibility is to create finance companies in the AFC, again using the same opportunities and flexibility for creation of the companies in the center, and then using those companies to lend money down into the group structures of which they are a part, and potentially raising money by listing debt securities on the AIX. And again, the AFSA and AIX teams can talk about this in greater detail in a few minutes. But if it's structured effectively, they can create tax efficiencies, and there can be tax efficiencies not only within the internal structuring of the group and the way in which cash flows move within the group, but also the taxation advantages in terms of both capital gains and income tax for investors who for Kazakh investors who hold AIX listed securities. If I could have the next slide, please. Financial institutions clearly are a principal target for the AIFC. We're going to hear in a second about the way in which they would seek and obtain authorization and the continuing obligations to which they would be subject. But there can be tax efficiencies not only in terms of their income, but also in terms of all the other financial benefits, such as subsidized locations and assistance financially and otherwise for their personnel. Again, that'll be covered in a second. For lawyers, obviously a subject dear to my heart, there are wide-ranging opportunities for the establishment of offices. It's a fairly complicated regime how they would be taxed, but in summary, my understanding is that if law firms are advising AIFC participants who provide themselves the relevant categories of financial services, then the revenue generated net revenue generated by the lawyers in advising those financial institutions from the AFC should enable the relevant segregated income not to be subject to Kazakh tax. Potentially, therefore, there's a difference between the taxation treatment of lawyers who are advising a financial advisor in the AFC who is acting as broker to an IPO, and the lawyers who are advising the IPO company itself. That is an area which would need to be analyzed in each case, but there are very significant opportunities for structuring law firms in a way which can take advantage of the benefits, physical benefits of location in the AIFC, and also the legal and regulatory support and all the other arrangements which are available to participants. Hotel and other support businesses, many of you will be familiar with the amazing Hilton Hotel on site. That is one of the examples of businesses which are being built up to support the infrastructure and the operations in the center. Can I have the next slide, please? very briefly and to conclude my discussions, the AFC law and dispute resolution arrangements touched on the previous presentation, and there are excellent webinars and other information resources available on both the court and the International Arbitration Center websites. But there is basically a freedom for anybody to choose AIFC law to govern their commercial relationships. No Kazakh connection is required. And that may be for political, technical reasons, highly desirable for a whole range of contracts. And in some cases, the choice of AIFC law to govern a commercial relationship is a mandatory requirement of certain Kazakh state contracts. Dispute resolution obviously is independent of that, but there would be a logic in choosing AIFC dispute resolution for contracts which are governed by AIFC law. There is a choice of the AIFC court, and included in the slide the summary of what they offer, which again I touched on last week, and also the arbitration center as an alternative form of dispute resolution. These two sources of dispute resolution can be incorporated under any contract. The contract does not need to be governed by AFC law, and there does not have to be a Kazakh connection. The court reserves the right to determine whether or not it will accept jurisdiction, but for most governing laws, it will do so, provided that both parties accept the jurisdiction of the court. To conclude, what I've attempted to do in the very short time available is to identify some of the ways in which the regime that we've all been working together to help develop, obviously under the guidance and with the AFC team doing all the heavy lifting of this, but there are all sorts of opportunities which will move towards the success of the center in due course, which I think represents and presents opportunities for all of us. I'm now going to hand on to the next speaker. Thank you very much.
Thank you, Simon. Let's turn it over to Nurkat Kushmov, Registrar of the AFSA. Nurkat?
Thank you, David. Thank you all the participants for participation in this event. I think it's very useful for us to understand the whole concept of the AFC. I would like to actually briefly discuss and provide information about the registration of the legal entities in the center, about which Simon already kindly touched upon. Next slide, please. The Constitution of the Republic of Kazakhstan and the Constitutional Statute provides the legal basis for the center to further develop its legal framework for registration of new legal entities, new companies and partnerships, and recognition of other foreign legal entities. So you can either incorporate new legal entity here or register foreign entity in the form of branch or representative office. There are many other requirements, but I would like to stress here several key ones. AFC territory is a physical territory on the left bank of Nur-Sultan city. You can see it on the slide. It takes most of the left bank and some parts of right bank of the city. It should have at least one director for private company and two directors and a secretary for public company PLC. There is also some implications of a tax law on company corporate law of the AFC, and CEO of the company must have an individual identification number, which is issued by tax authorities. We also have a very strict UBO, ultimate beneficial owners regime, which requires companies to notify us about the UBOs on registration, or if there are any changes within 30 days of such changes. And also there is fee for the registration, which is $300 US, and we also charge other fees on post-registration services. Next slide, please. There are several types of legal forms which you can establish in the center. They're very different to what we are used in the Republic of Kazakhstan, but they're very familiar to many of foreign companies and investors, especially those coming from common law jurisdictions. So we have several types of companies. The two first, private and public, the most familiar types. In any jurisdiction, private company is normally a very closely run company, and a public company where you can have unlimited number of shareholders. There is different regime for two of them, how you register your shareholders. Private companies require the notification of any changes in your shareholding structure to the registrar, while public company kind of leaves it to the company itself to arrange how the shareholding structure is registered. There are also three other types of companies, special purpose company, which kind of is a special vehicle which you could register here for particular financial transactions, for example, sukuk issuance or other financial transactions. Investment company, it's another one type of company which is very convenient for creation of funds and fund management, and it also kind of have a very permissible regime on how you register the members of investment company, your investors. We're also creating now, it hasn't been finalized yet, the regime for restricted scope company, which will allow shareholders of a company to have some information limited to public disclosure. It doesn't mean that we will not receive this information, but the information will be withheld from the public domain. Also, we have three types of partnerships. This is a general partnership where partners actually not limited with their liability. Limited partnership where one is a partner is a general partner and others are limited partners. Limited partnerships is a very convenient tool or structure for venture capital and funds where general partner actually the only one who can actually manage the company, and others participate as investors. Limited liability partnership is a very also popular structure within AFC, and this form is used by consultant and other professional organizations. We can also recognize other foreign companies and create their branches here, and we tend to recognize that the forms of companies which is similar to one of what we have. And we also have two types of organizations which are not commercial. This is non-profit incorporated organizations and foundation. Next slide, please. As already was mentioned before, one of the why we're kind of talking about the registration at all, this is because the whole entrance to the center requires you to incorporate the company and be physically present at the center. But however, there are other good advantages of AIFC corporate law, and they came from the status of this law, which derived from common law principles. And if we compare with other civil law jurisdiction, common law, corporate common law normally have much fewer number of mandatory rules, which enables companies to actually design the governance structure which is more comfortable, suitable for them, for their businesses, and actually have lower costs to run the business. There is no, and as example, for example, in a Kazakh LLP, there is requirement that other members of company should have the right of first refusal, which is very kind of inconvenient for many companies. Private company in the center doesn't have that. For public companies, for example, in Kazakhstan, there is requirements to have a two-tier board structure, where if you register PLC in the center, you can have either two-tier or one-tier board. As already was mentioned, there is a very suitable regime to create holding structure in the center. There are very few regulations around reorganization of companies. There is some for public companies which protect minority shareholders, but if you are a private company, the way how you reorganize the business is mostly up to the company itself. Although it already was mentioned that there is a regime where you transfer company to the AFC from another foreign jurisdiction, scheme of arrangement to, and different classes of shares. These three, the last three, I would like to kind of explain in a more details. Next slide, please. Classes of shares. This is a very kind of useful tool of AIFC corporate law. If we kind of look at Kazakh law, LLP, there is actually a very difficult, very limited possibility to create several classes of shareholders, while private company in the AFC doesn't have any limits how many different classes of shares do you have. So let's take a very good example as a Google. They have several, actually 3 or 4 classes of shares found for founders, for investors, and less kind of where investors have almost no governing rights but only economic rights. And you can structure is a very different way where you can have weighted voting rights for one class or have and more economic rights for another class of shares. Next slide, please. Transfer of incorporation, Simon briefly mentioned that to allow redomiciliation, it requires that both jurisdiction, AFC and another jurisdiction where company is registered, currently registered in, allows technically for transfer of a company from one jurisdiction to another. We are proud to announce that the last year we had the first company being redomiciled from Bermuda to the center. The case went very successfully and smoothly. This company also received financial license from us as well. There are many benefits to that. One is that you don't need to go through the liquidation process in the jurisdiction you're registered in, so that continuity of the business is remains. You can achieve it in a very short time frame, and you became the tax resident of Republic of Kazakhstan, which is you know, lessen your administrative burden under foreign company controls. Next slide, please. We also have a very interesting tool within our corporate law scheme of arrangement, which gives the company very wide kind of weaponry tools to restructure their business when they are not in a liquidation or not in a bankruptcy, but way before that, and they can apply to the AFC court and then restructure their businesses whatever way they want. And it actually doesn't limit, this tool is not limited to AIFC participants only. There should be some nexus to the center, but other companies from other jurisdictions could also be included in this such restructuring. We saw it in an English jurisprudence case law that English courts normally are willing to take the cases from foreign companies as well. Next slide, please. And I think this is the last one. Yeah. Generally, to finalize my presentation, AIFC corporate law is a very flexible one and very permissible one, and which allow you to actually achieve your business goals in a very fast way and in a very cost-efficient way. Thank you for the attention. This is all from me.
Thank you so much, Nurkat. That was an excellent presentation, very informative and quite interesting. Thank you so much. Now let's go over to Razak Basari, who's also at the AFSA, and he is the head of the Authorization Division. Razak.
Good morning and good afternoon, everyone. Thank you for participating today. I'll talk you through the various things the Authorization Division does, how it fits into the regulatory environment within AFSA. So, as the introduction says, I'm Razak Basari and I head the Authorizations Division within AFSA. If I can have the next slide, please. Okay, and my presentation today will briefly cover the functions and powers of the Astana Financial Services Authority, our regulatory objectives, the role of the authorization function within this, the threshold conditions for firms and the principles that we consider when we authorize firms, the fit and proper test that we conduct for individuals who perform key functions within these licenses or within these entities, and the principles that also govern this. We'll also have a quick look at the ongoing compliance obligations for regulated entities, and I'll talk very briefly about the supervision and enforcement powers of ASFA. That gives it a whole view of what we do. So if I can have the next slide, please. Okay, ASFA itself was established as a legal entity as the financial services arm of the AIFC. And we have various powers, but in a nutshell, we develop and draft AIFC acts relating to regulation. We can adopt various acts in terms of the form of regulatory provisions. As you've just heard from my colleague Nurhat, we also conduct the registration and recognition and licensing of various AIFC participants, and the Office of the Registrar and Authorization work very, very closely, because what happens is when we actually authorize a firm, we tend to authorize them in principle first, subject to them actually incorporating or registering their entity as a legal entity. We also exercise control and supervision over the AIFC participants, and very, very importantly, as a regulator, we enter into memorandum of understanding and bilateral agreements with various regulators around the world to ensure that we cooperate with them, and we not only cooperate with them, but we exchange information. And one of the key things we've done very recently, on the 20th of May, is we signed an MOU with the National Bank of the Republic of Kazakhstan and the Agency for Regulation and Development of the Financial Markets of the Republic of Kazakhstan. And this was signed as an agreement on the exchange of information. And what we're hoping with this is that eventually we could get to a stage where we have almost similar to what you have in the EU, where you could have passporting rights maybe between companies within the state or within the Republic of Kazakhstan coming into the AIFC, and AIFC entities also passporting into the Republic of Kazakhstan. And, you know, it's all about growing the regulatory and financial services within Kazakhstan itself. If I can have the next slide, please. This slide just gives you an idea of AFSA's regulatory objectives, and they're very, very similar to most regulators around the world. So in terms of ensuring that participants act in a certain way to maintain the safety and soundness of the financial system within the AIFC, things like ensuring fair and efficient, transparent and orderly markets, consumer protection, of course, fostering and maintaining financial stability, fostering the development of financial technologies. We have a huge fintech department or division, and financial innovation, technological innovation is very high on our agenda. And obviously, with a lot of what's going on within the world today, digital, online work, remote work, the innovation of different financial technologies is a key driver. And again, preventing and detecting, restraining and restricting any damage to the financial reputation of the AIFC in terms of money laundering. And again, these are very close to what you'd find in most regulators around the world. So next slide, please. And this is just, the next slide is just a organogram of the various divisions and what they do within AFSA. But the key thing for the authorizations division, which comes under the Managing Director, Chief Regulatory Officer. So right under that is the authorizations division, financial conduct division, Prudential division and capital markets division. And as I said, we all work hand in hand. Once we authorize a firm, depending on the kind of services or regulated activities they're performing, they might end up in one of those divisions there. And we perform the role of both gatekeeper and gateway. And if you just flip to the next slide, I'll explain what I mean by gatekeeper and gateway. Yeah, so we see authorization as a forward-looking tool in terms of being the gateway for firms or organizations to conduct various activities within the AIFC, be these market activities, regulated activities, or one of the various ancillary services, which I'll discuss in a few slides down the road. Again, we make sure that before companies can come into the AIFC, they fulfill certain threshold conditions and demonstrate certain fitness and propriety. And it's only then that we allow them in. So not only are we a gateway, we also provide that service as a gatekeeper to making sure that no one that will harm the reputation of the AIFC comes into the center, and to make sure that we only allow in companies that are fit and proper. And we're doing this, we do this in a manner that's proportionate in terms of regulation, flexibility, and recognizing the need for business within the AIFC. Next slide, please. Okay, this is just a representation of the various activities and services that AIFC participants can provide. So as an authorized firm, you can provide various regulated activities from capital markets, banking, asset management, insurance, fintech, and Islamic finance. We also have various market activities for our authorized market institutions, clearing houses, investment exchanges, operating private e-currency, trading platforms, and outside the authorized firms conducting regulated activities and the authorized market institutions that conduct market activities. We have a host of ancillary service providers that are ancillary to a lot of these activities, and you probably would struggle to do these activities if you didn't have these array of ancillary services. So we need lawyers providing legal services, auditors providing audit services, accountancy services, credit rating services, and consultants who advise and provide various assistance to our AIFC participants. But not only that, we also have a recognized non-AIFC regime where institutions and individuals can come in from other recognized jurisdictions to use the services or trade and our exchange, the AIX, as long as they're from a credible and a jurisdiction that's at least equivalent to what we expect. So you do get institutions that are just recognized by us. They're not licensed participants. They just recognized to perform activities and take part on the activities of our exchange. So we can have the next slide, please. Okay, I just mentioned the fact that to authorize, the phrase authorized persons just means an authorized firm. And when we have an applicant, there are various things that we consider, referred to as the threshold conditions that need to be met before we decide whether to issue a license or not. And these consist of checking that they've got adequate and appropriate financial resources in terms of meeting the minimum capital requirements and the ongoing financial commitments they would have. We also look at the adequacy and appropriateness of the non-financial resources. So do they have the right people, and do the right people have the skills, knowledge, and experience needed to carry out the various functions? So a typical example would be a company coming in to manage investments. Do they have individuals who have managed investments? Do they understand financial advice? What experience, what qualifications do they have? And that would really play on our minds. So they might have loads of money, but not the individuals, or they might have the individuals and not the appropriate capital. So it's a mixture of both. Again, I mentioned in one of the, well, I think it was the very first or second slide, that we cooperate with various regulators around the world, and we have these MOUs and bilateral agreements. These come in handy when we want to check the fitness and propriety of individuals or of a firm. So that firm's been licensed in another jurisdiction and the individuals have been approved in different jurisdictions. We can contact the regulators there to verify whether they're in good standing and find out whether there are any concerns, and all that information would have a bearing on the way we consider an application for a company and its individuals. We also look at the effective supervision. Can we effectively supervise this company or this applicant? And that would consist of, is it part of a very convoluted group? Do we have an understanding of exactly what this company does and what the group does? If it's coming in as a branch, do we have an MOU or bilateral agreement with the actual parent jurisdiction? Would be, if we had to do an on-site inspection there, would we be able to go there? And I have had experience of this in my previous life or previous roles, where I was licensing a bank in Lebanon. And at the time, Lebanon was going through quite a lot of political strife, and I had to keep on delaying my visit to Lebanon. Part of the visit, I met with the governor of the central bank at the time and a few other individuals, but the actual visit itself got cancelled at least 3 or 4 times before I finally could go there. And in the end, you know, it was just decided, no, we wouldn't be allowing a branch. They had to set up a fully fledged legal company and keep their capital within the country rather than establish a branch, because we just felt at the time we wouldn't be able to effectively supervise it as a branch. So we consider things like that. We also look at the compliance arrangements. Is the company going to be able to comply? Does it understand legislation, rules and regulations? Has it got a history of compliance? Would it be able to bring on compliance resources, maybe outsource them, but would it have enough to be able to comply? And again, for authorized market institutions, the adequacy and appropriateness of the technological resources, especially nowadays where a lot of things are done online, digitally. And again, if you're operating a trading facility, you have to make sure you have the appropriate and necessary technological devices, and that you have the security around these so you don't get hacked, or if you do get hacked, you can respond quite quickly. So if I can have the next slide, please. Okay, this is just a representation of the various principles that we consider for our entities or authorized persons. Again, this is very similar to what you find in regulators around the world, where there's certain core principles that we expect our companies to comply with and take note of. So they need to act with integrity, due skill, care and diligence. The management has to be sound. They have to have systems and controls in place. I mentioned resources before, and that's both financial and human resources. The way they conduct themselves within the market has to be upstanding. Information and interest, disclosure of information to clients, conflicts of interest, making sure that they put the interest of their consumers or clients first. Suitability, financial advice given to clients has to be suitable. Relations with AFSA, again, we expect our companies to be open and honest with us. Comply with high standards of corporate governance, have adequate remuneration practices in place that just do not foster sales, but also consider the suitability and adequacy of recommendations. And where they do hold client assets and money, that this is adequately segregated and kept safe. So again, principles that you'd expect authorized firms to comply with. And if I can have the next slide, please. And very similar to our providers of regulated activities, for ancillary service providers, we also have threshold conditions, and these consist of making sure that they're in good standing with any relevant regulatory body. So for example, where you have lawyers applying, we might check whether they're in good standing with a law society, of the relevant body from where the law firm is from, check whether they've got any disciplinary record or whether they actually have a good record. And we also look at their procedures for monitoring and preventing financial crime. Again, AML, CFT, combating financial terrorism is a big area for regulators, and one that we always look into to make sure that companies have the right procedures. Again, we also look at the risk posed to the AIFC by the applicant's activities and whether the ancillary service provider has the adequate controls to mitigate these risks. So every recommendation for an authorization is more or less an assessment of risk. So on one side, you're looking at the business risk. On the other side, you're looking at the controls and trying to decipher what the net risk is and whether that meets our appetite and whether the company has satisfied the threshold conditions. Next slide, please. For each authorized firm, we also have various key individuals known as approved individuals and designated individuals. The approved individuals need to be approved, they need to apply for that position, and they need to be approved by AFSA. The designated individuals are positions that need to be filled, but we just need to be notified. We do not need to approve these individuals. And I won't go into the various approved individuals or designated individuals, but in terms of the tests, we also look at the integrity of these individuals, the competence, and by competence, again, skills, knowledge, experience, that those three things come to form what's known as competence. The capability, you might be competent, but not capable just because you've got too much on. You know, especially where we get people multi-hatting or, you know, double hatting, treble hatting, you need to know whether the individual has got the capacity and they're willing to spend the time. Have they got too many fingers in too many pies? And how are they going to give your firms, you know, some time? Financial soundness. And again, this is not just about at the point of authorization, it's on an ongoing basis. Is the company likely to get access to further capital if it was to go into trouble or get into trouble? Who are the shareholders? What is their source of wealth? Are they able to inject more capital if they need to? All these are key considerations. Proposed role within the authorized person. If you're applying for an approved individual role or approved individual status, do you have the required skill? We do find, for example, cases of, you know, people with MBAs applying to be the finance officer or finance function of a company, and sometimes it might be a question of, well, yes, you've got an MBA, but do you know anything about finance itself in terms of auditing accounts and financial statements and international financial reporting standards? Just because you've got an MBA doesn't necessarily mean you know that much about financial statements itself. So we look at the proposed role within the authorized person and any other matters that we think are necessary in terms of considering whether the person is fit to fulfill the approved individual role. If I can have the next slide, please. And once we've then authorized a firm, we obviously pass that on to our colleagues in supervision, who then do the day-to-day supervision of each entity. And within that, we have various powers, powers to gather information, powers to require the production of a report, powers to impose a prohibition. Sometimes you might have a situation where there's been a breach or non-compliance, and until that breach is rectified, there's a need to impose a restriction or a requirement on a company. And our powers enable us to do various things in terms of asking companies to either stop certain actions or activities or put certain controls in place. There are also obligations for authorized persons in terms of, I mentioned being transparent and open with us, but the obligation of disclosure to the AFSA, if things come to AFSA, if things come to their attention, they need to let us know. So, typical example, a company's breached its minimum capital requirement. That's a reportable or notifiable event. They need to notify AFSA as soon as possible. Obligation to comply with various requirements by us, an obligation not to provide false or deceptive information, and of course the obligation not to obstruct us when we do on-site or even desk-based reviews. And on the accounting side, there are various requirements around accounting, providing regulatory returns, annual returns, appointing an auditor, an AFSA approved auditor, and when they terminate the service of an auditor, they need to let us know and the reasons for that termination, and the need to retain records and give us access to those records whenever we demand that. Normally, most regulators will have a minimum of 5 years in which you need to keep all record. It varies from regulator to regulator between 5 to 7 years. Next slide, please. And in terms of the ongoing compliance obligations for regulated activities, as I said earlier, we conduct off-site supervision and on-site. So off-site tends to be the desk-based monitoring and the receipt of various reports in which we then draw conclusions from those reports. And our on-site is when we actually go out there and inspect, lift up the carpets and see what's going on. In terms of the actual obligations of the firms themselves, they need to provide prudential returns, which will include liquidity and capital reports. Where they do stress tests, we want to see the results of those stress tests, or the insurance companies or the banks. They continuously have to stress test their capital and stress test various scenarios. I mentioned there is, provision of annual financial statements. Same thing on the money laundering side. The MLRO has to provide certain reports, client money asset reports in terms of client assets reconciliations, making sure that the money is segregated and providing those reports to AFSA. Sometimes we might ask for specialized on-site inspection reports and various notifications. We do thematic reviews around various themes, and we could ask for specific specialized reports and sometimes periodic meetings with the senior management of the companies. And the whole idea behind this is to get an understanding of the ongoing risks within the business, the control environment, and again, to make sure that these companies continue to be compliant with our rules and regulations. Next slide, please. And I think this might be the final slide. Again, you have, this is more or less, your cradle to grave, where you have the authorization, supervision, and you've registered the company. And at the very end, sometimes, depending on how things go, we do have enforcement powers. We tend to use them very sparingly. We don't like using these, but from time to time, things do come up. And again, We have powers to conduct investigations, to require certain information, to use information as evidence in proceedings, the power to impose disciplinary sanctions, and the power to require firms to appoint a manager, and other powers as confirmed by the acting laws of the AIFC. So we have a head of the enforcement division, and from time to time cases will be referred to him, and we have an enforcement committee that will decide whether there is sufficient evidence to carry out further investigation and to build a case against a company where there's been a transgression. Next slide, please. And that's it. So if you do have any questions, as Simon said, at the end of all these presentations, we will take questions, and thank you very much for your attention.
Thank you, Razat. Now let me turn it over to Eugenia Bogdanova, Head of Regulation and Compliance at the AIX. Eugenia.
Good day, everyone. So let's speak about Astana International Exchange. Next slide, please. So AIX was established in 2017 as a part of Astana Financial Center with a goal to become financial hub in Central Asia for both global and local investors and issuers. On the next slide, you will see AIX shareholders. The majority stake is held by AFC itself, and other shareholders include Shanghai Stock Exchange, Silk Road Fund, NASDAQ, and Goldman Sachs. So the idea was that the financial center should operate in the regulatory environment familiar to international investors. So AIX operates under the acting clause and judicial system of AFC based on the principles of English law, as Simon mentioned earlier. So AIX provides equal access to local and global brokers. Currently, we've got 24 brokers, including 7 international brokers. So to get access to AIX market, a local or international investor shall become a brokerage client of those trading members. And basically, you would be able to trade any instruments listed on AIX, and those could be traded in any currency. And the good side is that investments on AIX are not subject to the capital gain tax and tax on dividend. So on the next slide, you'll see description of the trading and post-trading infrastructure of AIX. So all these are reliable solutions delivered by internationally recognized providers. Next slide, please. So AIX provides opportunity for companies to get additional financing on capital markets through equity and debt offerings. AIX also known as a platform for largest privatization in Kazakhstan, but due to pandemic outbreak, the big privatizations are likely now pushed to 2021. So there are various instruments and structures available to issuers for capital raising. And AIX team will work closely with the potential issuers and their advisors to choose optimal offering structure depending on the issuer's readiness and fulfillment of listing requirements. Next slide, please. Specifically, I wanted to highlight 2 options. The first one is more suitable for larger issuers who seek primary listing, for example, on London Stock Exchange or Hong Kong Stock Exchange with the secondary listing on AIX. Currently, there are 5 exchanges recognized by AFSA as equivalent, and you will see their logos on the slide. So at this point, there's a one-way recognition, but at a later stage, we also will work on establishing mutual recognition, so our issuers may benefit in case they seek listing on those exchanges. So in case of such dual listings, to avoid duplication, AX streamlined its application process by recognizing equivalent criteria. For example, issuers would need to prepare only one disclosure document, prospectus, and AX would recognize international prospectus. And for post-listing obligations, there will be no need to disclose anything beyond what is being disclosed on equivalent exchange. There is a condition that the issuer should do simultaneous mirror disclosure on AX, and the disclosure should be in English language. So in case the issuer breaches its disclosure obligations on the primary exchange, then it would be required to comply with AX disclosure requirements. Next slide, please. So the second option is a brand new segment called regional equity market for medium-sized companies from Kazakhstan and the Central Asian region. The initiative was launched this year, and it's currently undergoing a public consultation process. So the consultation paper is available on AX website, and you can find it there, or if you don't, you can drop me an email and I will provide you with a direct link. So who are the RAM issuers? So those are medium-sized companies which seek listing of its shares on AX only. For this segment, GDR listings will not be eligible. So when we say mid-sized company, we're saying that the expected free float market capitalization should be up to $200 million. In case a free float market capitalization remains above 200 million for 12 consecutive months, the issuer will have another 12 months to transit to the main board and comply with the main board ongoing requirements. So at the time AFC was set up, the objective was to create an environment which is familiar to international investors and issuers, and to adopt best international practices. So at this point, the main board requirements actually matching the highest standard for premium listed companies. And this standard not always suitable for smaller companies. So as a part of our reform, currently we are looking to optimize listing requirements for smaller businesses. And these modifications would include simplified prospectus, which shouldn't be more than 30 pages. We would require disclosure of only 1 year audited financials as opposed to 3 years. There will be no requirement to demonstrate net profit for previous years. The free float requirement will be reduced from 25% to 15%. And also, we will extend filing deadline for the first annual report by 2 months from the regular due date. Also, we're simplifying corporate governance requirements for all equity issuers, including REMs. And we will adopt a differentiated approach for issuers of equity and debt instruments. So next slide. And before I pass the floor to my colleague Arman, who will discuss peculiarities of listings of mining businesses, on this slide, you will see the completed offerings and the existing issuers on AX. Thank you.
Yeah, thank you, Evgenia. Good afternoon to all the colleagues, and thank you for staying so late in the presentations to listen to mine. I'll be talking about a very important segment on AIX, which is the mining companies. Next slide, please. As you may know, the government started paying increased attention to the mining sector. Obviously, during the independence years, most of investments went to the hydrocarbon sector, oil and gas, and with the mining being to some extent underinvested. And in 2018, a new code, a new subsoil use code was adopted. It's been worked on for 2 or 3 years by different divisions and the industry, and it's modeled on Australian and Canadian, to a lesser extent, Canadian models. The main feature of new code is the way subsoil use licenses are awarded. It's based on first come, first served basis. And that already brought some promising results. In less than 2 years after the new regime was introduced, over 600 new licenses have been issued to companies, and that, in 2 years, that doubled the number of outstanding licenses that existed for over 20 years of independence. Also, there are different initiatives and programs to support the sector. There's 200 million. The Ministry of Ecology and Geology estimates that the exploration alone requires about 200 million a year in investments. The government allocated about 500 million to exploration until 2025, and expect that amount to be matched by 2 billion from private sources. These are figures from pre-coronavirus, so those may change, hopefully not too much. Also, Tauken Samruk, which is a national mining company, has its own program to support junior mining companies valued at less than $100 million. Again, it's a pre-coronavirus figures, and we expect new changes soon. Generally, the environment, the conditions for mining companies and the development of the sector are very promising and attractive in Kazakhstan. According to official estimations, there's over 1 million square kilometers available for new exploration, over 7,000 mineral deposits potentially discoverable and available for exploration and development. And there's a comparatively low costs of exploration and development for miners in Kazakhstan compared with other regions. Next slide, please. So in line with this initiative, AIX adopted its own mineral companies rules in August last year after some consultations with the industry, with the regulator. The rules are basically modeled on Toronto Stock Exchange and Australia Sydney Securities Exchange rules and practices. We have 2 tiers of companies. The first tier available for more advanced companies, I would say, for companies that approach the production stage, and the requirements there are more stringent, with the main requirement being the availability of a JOC, this is Australian CPR standard, or NI 43 101 compliant CPR with the post-listing semi-annual reports, with the annual update for the CPR, the existence of 3 years audited accounts, and expected aggregate market value of shares of at least $1 million. The second tier issuers are, less, I would say, stringent, the more relaxed requirements. Not only JORC or NI 43-101 CPR is accepted, but also Kazakh RC compliant CPR is accepted there. There's no requirement for track record. Basically, we're talking about startup companies with obviously very high risk profile, with no aggregate market value requirements. So you can talk about a few $100,000 or even a few tens of $1,000s threshold. Whatever is economic for a company to go public, that's acceptable, good for us. So we have these 2 tiers. We had some questions from the industry when we worked on the rules, when we consulted with the industry. Some potential issuers wanted Kazakh CPR available to first-tier companies, but out of our concern for investors and for the quality, we decided to keep the Kazakh standard only for tier 2 issuers. That may change as the CPR quality develops and grows in Kazakhstan with Kazakh CPR service providers. Next slide, please. So what AIX offers to issuers and investors as opposed to other exchanges in the region? Basically, our admission procedure is streamlined, it's transparent and clear, and it's according to our estimations, it would take between 4 and 2 weeks for a mining company to be admitted. We have 8 international brokers connected to our trading system, fully able to trade on AIX. Among those brokers are Renaissance Capital. Those of you familiar with that broker would know that they are very experienced in the mining and metals industry. They led a number of private and public transactions in the CIS market and also African market. That's a lot of similarities with African market we have. Also, we have China International Capital Corporation, or known as CICC. That's very active on Hong Kong and mainland China, and its institutional investors portfolio has over 20,000 investors, and a large number of those are essentially very experienced in mining and metal transactions and sophisticated. As Evgenia mentioned earlier, we have this recognized exchange regime available for those companies already listed on the main market LSE, AIM, Dublin, Hong Kong Stock Exchange, and Shanghai. That's the procedure for those companies is fairly easy and quick. Also, we conduct a number of promotional events for junior miners. We did a few of those last year. We planned many for this year, and due to coronavirus, we have to change the format of those. But obviously, we hope to catch up until end of the year with more events, probably online events for investors in the sector. Also, the option of subsidizing market making and professional research coverage is available for minors on individual basis based on individual circumstances. Obviously, for investors, we have the region that is quite known for rich natural resources, minerals, such as Russia, Mongolia, and Uzbekistan, and probably a longer-term objective is to have more issuers and more investors from those countries. And as Evgenia mentioned earlier, there are tax benefits available to investors who invest in securities listed on AIX, both equity and debt. Next slide, please. So what we have in the sector for now is obviously we have Kazatomprom, which is not a classic mining company. Of course, it's an integrated nuclear company, but the mining is a significant part of its business. We have dual-listed polymetal and ferroalloy. Ferroalloy, I think, is an interesting company. It's more, it fits more the definition of junior miners. We expect more companies such as ferroalloy to join our listing. Ferroalloy listed in January this year, and it delisted from CASI, and I understand they have significant plans for AIX, and we look forward to working with ferroalloy and the companies that are similar to ferroalloy in the coming near future. We have the pre-IPO segment that's worth separate discussion. Basically, it's the companies who are preparing themselves for a full IPO, but they are already eligible for certain benefits as if they were public companies. And in that category, we have Kazkrom and Shubarkol Komir. And also we have debt from Altyn company, bonds. It's a $10 million bond, and it's an interesting company, an interesting instrument. And we expect more debt instruments such as Altyn's in our list. I think I'm done, and I'll be happy to answer questions at the end of the presentations. And the floor is now another Armand Bataev's. Thank you.
Thank you very much, Armand. Now let's turn it over to Armand Bataev, Senior Manager or Deal Sourcing at AIFC Business Connect. Armand?
Yes, hello everyone. Thank you for staying so late. I'm the last one to present. Can you please go to the next slide? So I will briefly go over our main purpose, function, and services of AIFC Business Connect. More detailed presentations we will hold in the next sessions. So main purpose is, of course, as it was mentioned previously, attracting foreign direct investments and driving economic impact into Kazakhstan through AIFC infrastructure. So AIFC Business Connect is part of AIFC family. And we try to attract participants to AIFC and support existing ones We see legal firms and other consulting companies as our main partners in attracting new businesses to AIFC. And we define and source suitable investment projects through various sources, of course, through government sourcing agencies, national companies, and different business associations. And we also strive to structure projects into suitable models. And as you saw from the Nurhat's presentations, we have necessary organizational forms. And from Simon's presentation, you saw that we operate on English common law, which also is very familiar to many supranational agencies. And we, at our premises, we have several supranational agencies who are located here, which makes it easier for them, with them to interact. And we also drive investment into suitable projects. All our team members are coming from industry, so have experience in mining industry, consulting companies, and oil and gas companies industry. So we know what industry and businesses want, and we try to deploy specific value propositions by segments. Next slide, please. And here is brief customer journey. So what we do as AIFC Business Connect is we are doing we conduct market research to implement international best practices, understanding needs of customers, and develop suitable projects. Then we we give consideration to clients and who are guided and consultant regarding the services and products provided by us. So our sales team and participant support, deal sourcing teams are interacting with our leads. So we provide, like if AFSA, AFSA authorization acts as gateway and gatekeeper to our jurisdiction, to AFC, we see ourselves as friends and partners to prospective participants. So we help them with registration, authorization support, and provide them with necessary templates and guidance. We also, our team members from deal sourcing and deal structuring try to advise and recommend on suitable organizational forms, and try to give necessary contacts with government agencies and other potential co-investors from our databases. So in deal sourcing, we have databases not only of projects, but also investors who are seeking investments into various industries. So after sales services, we have post-registration support. So these are usually if you need to change your shareholders, you need to change your structure, or you have new deals. So we assist with that, understanding that English common law is not maybe some of the Kazakhstani projects is not familiar with that. And if you can't find suitable products, as AIFC Business Connect, we have market research team who will analyze the viability of a new product. Next slide, please. So here is a brief journey on our deals. For the short time that our financial center exists, we built a business flow for our leads. So we are like defining and sourcing suitable investment projects from government agencies, national companies, and different associations through signing MOUs and NDAs. So if you have like project which you want to attract co-investors and you would like to give it visibility, we will be very glad to see it in our databases. Then we will structure projects using suitable organizational forms and considering all the stakeholders and parties that will take part in the deal. And if our sales team is also at your disposal to at your service actually to help finding investors to your projects. And the main type of investments projects that we see great prospects is of course mining industry. As Arman previously mentioned, there was change in subsoil use contracts, and we see from a public register of AFSA that lots of mining companies are registering, and most of them actually have foreign shareholders, which is also publicly available. And for agricultural companies, they prefer to establish their holding companies at AIFC, which also has many benefits. So employing English common law, like trying to have asset protection and use like tax benefits, especially financial companies. So asset managers are also registering, and we have, as I mentioned, many ancillary service providers, legal firms, consulting, company service providers, who are bringing new businesses to AIFC and giving it visibility in other jurisdictions and countries. And one other industry which is prospering is crypto, which is quite understandable because of like crypto mining farms, because of low electricity prices. We have also companies who are registered at our with AIFC. We also recognize like some of the electronic payments and crypto asset as an asset. So we have a friendly environment for like not only classic financial companies, but also for new fintech companies also. So this is the last slide, and as I mentioned, we will have like separate sessions in detail. So Dave, I'm turning over to you to Q&A.
Thank you very much, Arman. With that, let me turn it over to my colleague Almas, who will check whether there are any questions coming in from the audience. We have run a bit over time, but we do have time for maybe one or two questions. So anybody at all, please raise your hand with the icon.
Yes, also, dear guests, you can send your questions to our chat and I'll be pleased to read it. you can send it to me directly.
Okay, Almas, so you're receiving any questions?
Not yet.
Okay, let's give it another few seconds.
Yep, sure.
Okay, all. With that, I want to thank our distinguished speakers from the Legal Advisory Council as well as from the various AIFC bodies. I know we ran a bit over, but the webinar was filled with very rich information. And please stay tuned because we will be following up now with more granular, detailed, practice-oriented approaches, both knowledge and practice skills in the coming weeks, and particularly in the areas of the AIX listings and related matters, as well as within AFSA compliance and anti-money laundering sessions that will sure to be extraordinarily valuable. Thank you for everyone, and we look forward to seeing you again. Bye-bye.